So without further ado, I'd like to introduce our first speaker this afternoon. Professor George Szmukler is Professor of Psychiatry and Society at King's College London, who has an interest in mental health, particularly the use of generic legislation centred on impaired decision-making ability and methods of reducing compulsion and coercion in psychiatric care. He is co-director of the King's Health and Society Centre, which provides a framework for interdisciplinary research linking health and healthcare with the social sciences, law and the humanities. He is also an associate director of the NIHR Mental Health Research Network. And he will address the criteria for involuntary detention with a particular emphasis on the use of risk as a basis for detaining people with mental health problems. So I'll ask you to join me in welcoming Professor Szmukler to address us.
Thank you very much. I'm very pleased to be here. I hope what I say is of some interest and help and not discouraging. And I'm not going to address exactly the criteria that you might wish to see in mental health law in Ireland. But I want to really take you through the kind of progression of ideas about mental health law or health law involuntary treatment that my two legal colleagues, John Dawson, Roy Lador and I have been going through for the last 20 years or so. So we started off from the point of asking the question, why is it that we have these two regimes for decisions to be made when people are not able to make a decision themselves? So in most jurisdictions we've developed health laws. There are these the capacity-based law or guardianship law, and then the specific law. Ireland is an example of that, as is England and Wales. Now, why is there a difference? People with physical disorders, the law seems to set very high store on the notion of autonomy or self-determination, and that one could only impose treatment on a person who suffers from a physical disorder, and go to covers, if they have an impairment. They have an impairment of decision-making capacity, and the treatment is in their best interest. And I'll come to these difficult terms a little bit later, but that's what, for example, Mental Capacity Act says in England. But mental disorder, the legal regime is governed by completely different rules. Autonomy, or the right to self-determine, is not respected in the same way, and that most involuntary treatment statutes in mental health have the notion of suffering from a disorder, which is usually not very well defined, and indeed very difficult to define what that means, and some issue about risk to self, to one's own health or safety, or for the protection of others. That's the general system, and the treatment is warranted and maybe can't be given outside the use of compulsion. But basically, a status definition of a person's mental disorder and risk. And the question is, well, why should this be? I'm ashamed to say it took me 20 years to ask this question, even though I did my dissertation on compulsory treatment in the London Borough of Camden in 1980 or something. And I think there is an underlying stereotypic, discriminating idea that people with mental illnesses are not fully persons. That one doesn't need to ask about whether they have the capacity to make decisions, because they've got abnormal minds. It's not a meaningful question. Of course, they're not quite capable of making decisions. Well, of course, the research literature is absolutely against this, so that even people who are admitted to the Maudsley Hospital into acute admission wards in the last few years, and you have to be very, very, very disturbed to be admitted to a psychiatric hospital in London now, that 50% roughly of those people had decision-making capacity. So these are the people who are most likely not to have it. So this stereotype is really absolutely unacceptable and wrong. Now, protection of others, I think if anything this is even worse. That most mental health laws has the mantra of protection for self and protection of others, that they're linked together as if they're referring to the same kind of values or same kind of ends. And in fact, when one thinks about protection of others, the issue here, the key issue, turns on risk rather than any health interest for the person. Whereas treatment in the interests of the health of the person turns on a health interest. So that we have this very unfortunate situation. So if you imagine in the red circle, everybody with mental disorder defined as very flexible. In the blue circle, you have risky persons in society, and you have this area of overlap, this lentiform area of overlap. And we have this very unfortunate situation that I think virtually the only group of people in our society who can be detained on the basis of perceived risk without having had to commit an offence or an act which clearly, or to be strongly believed to have been committed an offence and to be placed on remand. But this is the only group of people who can be detained on the basis of risk, on the basis that they fit this category of mental disorder, which there is a tremendous temptation in society, as you can imagine, to expand that circle to include troubling individuals, as for one reason or another. But such people can be detained, whereas all the other risky people, let's assume that everybody there in the blue circle presents an equal risk, if one can evaluate risk accurately, which will come to that. Let's assume that they present an equal risk. Surely justice, fairness, would require that equal people should be treated equally, unless there's a reason for them not to be treated equally. If they all present an equal risk to others, surely they should all be equally liable to detention. So what would follow from this is, if we are serious, perhaps, about some kind of actions to reduce risk, to reduce harm in our society, that all of those people in the blue circle should be equally liable to a risk assessment and to detention. So that would include people who drive dangerously, people who beat their spouses, people who get in fights in bars, drink excessively. That they should all be equally liable to detention, so that people within the thick blue circle should all be equally liable. Now, that would lead us to some kind of generic dangerousness legislation, where beyond a certain threshold of riskiness, society says, sorry, we can't tolerate this, we're going to have a hearing, and that perhaps some people will benefit from mental health care, and those people, under what circumstances, they should be directed towards mental health care, but if others don't, would not benefit from mental health care, well then they might need some other kind of surveillance, monitoring, custodial sentence, or perhaps one of the arguments that people use, when I say to people, why should this group of people with mental disorders be treated differently? They'll say a number of things. It's easier to tell that they're risky. Well, there's no evidence for that at all. Or that there's treatment for people with mental disorders. Well, you go and tell that to people who've not been there for 20 years because they're risky. Isn't it the case that it is, if you wanted to really reduce harms in society, that if one were to treat those risky persons in the blue circle with things like anger management, interventions for drinking excessively, interventions for getting people to drive more carefully, interventions would save a lot more lives in our society by doing that. But I'm personally not in favour of preventive detention, not in favour of dangerousness legislation. The only point I would make is that whatever the rest of us should have should be equally applicable to people with mental disorders. So if we do have dangerousness legislation, it should apply to everyone. If we don't have it, it shouldn't apply to anyone. It shouldn't selectively select people with mental disorders with a special privilege of being detained. And as far as that circle is concerned, we had a situation in England where a state-established diagnosis, dangerous severe personality, was included to expand that circle and to make it possible to detain people, even if there was no treatment available, because of the risk that they were deemed to pose to others, without their having actually committed a crime. So I think this is a very serious situation, very serious issue. And it's discriminatory. I think clearly discriminatory. Why does that situation exist? Why do we not question it? I think it's another stereotype. People with mental illness are dangerous. They're dangerous people. There are two stereotypes the incompetent person, a person who's not fully a person, fully autonomous, or a dangerous person. And every objection to what I'm going to talk about, diffusion law, you will find at root one of these, or both of these stereotypes, will be raised as a reason for the exceptionalism of mental illness. We'll see how perception works. On the issue of risk, I'm not going to spend a lot of time on it, because the evidence is so clear, and Dr. Kennedy will probably disagree with this, but if we are really wanting to have risk assessment to prevent serious harms to other people, firstly we have to look at the frequency of these events. And I put some up here. There's homicide. 1 in 10,000 patients with a psychosis in a year will commit a homicide. I mean, there's no way you're going to pick that person. Strange homicide, 1 in a million. You know, same risk as being struck dead by lightning. Now, this is from my own trusts and figures here. Significant violent incident, 1 in 200 patients. Significant means, I think, means that there was some kind of treatment needed for the person who was the victim of the violence. But 1 in 200 patients out of 34,000 patients seen in that trust, and in that year there were about 120 who committed an act of significant violence. And serious violence was 1 in 1,400 patients. Serious violence is pretty rare by people with mental illness, despite what you read in the newspapers. Psychiatric inpatient suicide, I was prompted to look at this because of the recent Rayburn case where, well, I won't go into the details, but the risk was said to be sufficiently high that the trust should have taken action to detain a person who committed suicide on leave. She was an informed patient. So I thought, well, what is the risk of somebody in a psychiatric hospital committing suicide during that inpatient period? And presumably they're extremely high risk. And that includes periods on leave. 1 in 14,000 patients. In SLAM, I looked at the same, and it was 1 in 15,000 patients. There was 1 inpatient suicide in 3 years, and about 5,000 patients in the year. Now, there is no risk assessment instrument that can deal with the problem of low frequency or low base rate. And what I've done here, and I'm not going to go, I don't have the time to go into huge detail about this. It shows you the percentage of correct prediction at different base rates. So if something occurs 5%, then this is the best test. This is the MacArthur Foundation test of risk, which on replication is not as good as I've indicated here. This is the best test, backed up with a huge amount of research. It's very detailed. So, 5%, you're going to be wrong 86 times out of 100. At 1% or 2%, which is an act of significant violence, you're going to be wrong 94 times out of 100. I mean, what kind of basis does that present for making a decision that somebody should be detained? There are so many people who are unnecessarily being detained, coerced, monitored, put on community treatment orders and so on. And so we have to appreciate this extraordinary limitation. There is no meaningful risk assessment for rare tragic events. They're the ones that we're trying to avoid. I think just the point that in the absence of antisocial personality and substance abuse, the recent epidemiological evidence is that the risk of a psychotic person committing an act of violence is modestly, if at all, increased above the general population. Antisocial personality and substance abuse, yes, increase the risk enormously, but they do so in people without a mental disorder. Sorry.
The last thing. Repeat the last phrase.
But the incidence of violent incidents in people with psychosis in the absence of substance abuse or social personality disorder is modestly increased above the normal population. Okay, now, recent history of legislation in Wales. This was a fairly drawn-out event, went on for about a decade. There were sustained criticisms against the government's proposals. There were 2 bills that were finally withdrawn, and finally there was an amendment to the Mental Health Act, which introduced, actually, I thought, the elements that most people had objected to how attacked, for example, community treatment order, and the inclusion of personality disorder as a mental disorder, and the removal of the treatability criteria for people with psychopathy and whatever. So the problem here was that at the same time, just like here, there was this mental capacity legislation going through. And it was just extraordinary that you had these two bits of legislation talking about people with some kind of impairment of mental function that were arguing completely different rules and principles. And nowhere did I see a coherent argument about why one shouldn't apply to others. I mean, maybe we should have something like mental health law for all law. So you go to see your doctor. The doctor says, well, you know, you've got a condition, you would benefit from bypass surgery. And you say, well, actually, no, I don't think there's nothing to risk it. The doctor says, well, no, I think it's in your best interest, you know, that you have it, so you will have it whether you want it or not. I mean, that would be the opposite, wouldn't it? Well, we were appalled by that, but we do that in terms of mental health law. So, you know, why was there such a resistance by the government to having a single act, which I'm talking about, is the solution to the problem, although it raises some other problems, undoubtedly. So what we had was this amended act, and we have these two separate acts, which don't cohere. So you might have a situation where you have somebody who's got a mental disorder and physical disorder, and the treatment of each of those is governed by entirely different rules. And that gets even more confusing when the physical disorder causes the mental disorder, or the mental disorder causes the physical disorder. So Liam Brady went on a hunger strike, and this was regarded as a symptom of his personality disorder, and so it could be treated under, although Jones thought he was, So two regimes which just don't connect because the criteria are quite different. Mental Health Act has this group of people with mental disorder, and then an issue of risk, and Mental Capacity Act, which is about the person's ability to make decisions and best interests. And then when you throw in deprivation of liberties, that people actually can be detained under both regimes, it becomes very confusing. So the proposal that my colleagues and I put forward is what's known as the fusion law proposal. Basically, we're saying that why do we need separate mental health law at all? We're talking about people who are unable for one reason or another to make decisions about treatment or maybe about social care and other kinds of decisions. Why do we need these two separate laws? So we're talking about a single statute that would cover all persons, no matter what the cause of their illness or of their decision-making capability impairment is, whether it's psychiatric or physical, really doesn't matter. Do they have a problem in being able to make a decision? And then some rules about if they do, so when would it be reasonable to and according to what principles would one decide whether they should have good treatment? And the reason we're calling it fusion is because we're not throwing out civil commitment altogether. Civil commitment is hopeless on autonomy, it's very good on regulations, so that if we're going to have a single law, there will be people who will be treated involuntarily, and some people say this is not possible under the CRPD. I think there will be people who will be treated involuntarily, and you have to have regulations for that. You have to say who can authorize it, where they can be treated, for how long, what kind of review process, what kind of appeals process. You need to have that. And the Mental Capacity Act, now 69 sections, has one, and the use of force that says it has to be proportionate, basically. Proportionate to the seriousness of the crime. I mean, it won't work if we're to cover the whole range. And of course, there is a lot of compulsory treatment that goes on in general hospitals. A lot of patients are being forcibly detained in general hospitals after an operation. When they're confused, they want to wander off, pull out drips or catheters and wander out onto busy streets and so on. So remember, what we are talking about is a single regime that covers absolutely everybody. It's not mental health law at all. So the principles of our fusion proposal basically are they're built on the mental capacity. Now we did this before we had fully grasped the discussion around the CRPD. So the Convention on the Rights of Persons with Disabilities. So let's just consider how we formulated this and then look at whether it's compliant with the convention. And so we're saying that basically people assume to have decision-making capacity unless they lack it. I'm going to call it DMC decision-making capability to separate it from the notion of legal capacity. In our fusion statute, we have called it capacity decision-making capacity. That one must take all practical steps to help the person. An unwise decision itself is not sufficient to say a person lacks DMC. Any act for a person who lacks DMC must be done or made in his or her best interest. I'll come on to this thorny notion of best interest. But the notion of best interest we have is the one about what the person would have chosen if they were in this situation and had choice. That's very clearly what we have in mind by a best interest. It's not objective best interest. It's not what somebody else thinks is best for the person. Less restrictive alternative, but nothing sort of terribly different there. The definition of decision-making capability, and here I think we've appreciated that the Mental Capacity Act definition is really not adequate. It works for the majority of people because if we take the people who are admitted to the Wolsey Hospital, of those who lacked decision-making capability, about 50% failed on the first test, understanding the information. So if one were to give the person the information, they couldn't repeat it back to you. So there was, because they were so preoccupied with other things or whatever. So in fact, those criteria work for the majority, but there are difficult cases, and lots of people about anorexia nervosa, where there seems to be an issue of beliefs and values which are not covered in this, what appears to be a procedural or a cognitive assessment capacity. So the person with anorexia nervosa says, look, I know that if I don't eat, I might die. And if I do eat, I will survive. However, I value being thin more than life itself. Well, the logic there is pretty clear. Another case was Kerry Wool-Taunton, who presented to a hospital having taken some antifreeze, who said, I have taken this antifreeze to die, I've come to the hospital for you to make my death comfortable. I do not want any treatment, I don't want dialysis. She appreciated, totally understood, cognitively, procedurally, that if she didn't have the treatment she would die. She said, yes, that's right, that's what I want to do. Now, I don't think, that pulls against most people's intuitions, particularly the anorexia nervosa folks, that it's odd to value being thin more than life itself. What kind of beliefs or values underlie that? And are there ways of assessing beliefs and values in a way which has a sufficient degree of objectivity? There's no gold standard, it's not going to be objective. I could talk about this a lot, but I think that there are ways of assessing beliefs and values, of interpreting what a person's will and preferences are. And it involves more than just looking at the idea and saying, it's an odd idea. You have to look at the person. You have to look at how that idea, those values, those beliefs relate to relevant other beliefs and values. So for philosophers, Davidson's radical interpretation, I think some colleagues would argue, that opens up a way of thinking about beliefs and values and establishing their coherence as a body of beliefs and values, or their correspondence with reality. If somebody has a delusion which is really impossible, then one has to say there's a real problem with belief here. Bizarre, impossible delusions, like, I flew here from Heathrow, but without a plane. I just did it myself. I don't have any special powers. So all I would say here is there's a lot of work still to be done on decision-making capability, particularly around beliefs and values, and I think people are working on it. I think there are some ways forward. Remember, these are complex judgments. They don't have the precision of reading an X-ray. Although I must say that in our group, when we rated whether people had decision-making capacity or not, based on opinion, we had extraordinarily high reliability, iterator reliability, but that all work in the same place, perhaps see the world in the same way. Best interests. Okay, so in our fusion proposal, we have best interests, which is pretty much defined as in the Mental Capacity Act. But we take very seriously the idea that the person's perspective and view, wishes and preferences are paramount. We don't take the view of objective best interests. And so when we are asking, when we're considering what the person has said in the past, what they say now, whether they've got an advance directive, whether a statement, whether they've got a statement of values, principles, whether they've appointed somebody as a representative, these are all trying to get at what the person's will and preferences are. When we ask other people about the person, what we're trying to find out is not what the other people think the person should do, but really, can you help us to understand what that person's choice might have been and why, what are the values, what are the underlie, what kind of life choices, what kind of life project does this person have, how would this decision fit within that and how they'd like to decide. So our statute has a number of elements to it, and forever it's just a single statute, which makes some of these things more straightforward. So we have a general authority for just routine care that allows people to do some routine care things, like go out and buy shopping for somebody who says, I don't want it, without having to go through formal procedures. And then we have deprivation of liberty, which we have to take note of, but which I personally think is appropriate. And what we are saying is that deprivation of liberty is when somebody with impaired decision-making capabilities, for whom deprivation of liberty is in their personal subjective best interests. And there is a definition of it, which we are saying is unable to leave, essentially. One may include a subjective element. I was going to talk more about this and say that what I'm saying is impossible. The subjective element that the person really does not, in any sense, assent to being there. So they believe that they are being detained. And we have a system for deprivation of liberty which involves the registration of the person as having deprivation of liberty, a responsible commission who says that we will certify about decision-making capacity, best interests, and so on. That we have a care plan that has to be discussed with what we call substitute decision maker or representative or facilitator. And then if it's going to go on beyond 28 days, there will be a second opinion from another health professional who's been trained to do this. At any point, anyone can appeal to a tribunal, and so that would be our deprivation of liberty safeguards. Serious medical treatment, similarly, if somebody lacks capacity, and they're going to have some serious treatment that may be irreversible, that will be very risky, we think similar kind of safeguards need to be placed. And then we move on to involuntary treatment and forensic issues. How much? Good. I'm sure I haven't. Because we started a bit later. Anyway, okay, so for compulsory treatment, these are the criteria we have set up. Remember, this is not just in mental health, this is across the board. And the important one here, I think, is the objection. The difference between deprivation of liberty and involuntary treatment is the objection. And because we have a single statute, all based on decision-making capability, one can work those things together. If you have different statutes, as we have, as you're probably going to have, there's going to be a problem unless the criteria in the mental health statute are similar to the criteria in the mental capacity statute. And I thought, how can one get around it? And I can't ways to get short of that, really. And so this process of involuntary treatment or non-consensual treatment involves emergency provisions. Staggered assessment, so we're suggesting, for example, a person can be held for 24 hours if there is reason to believe that they have an impairment of decision-making capability and that it would be in their best interests as far as one can determine. Then after 24 hours, if the person is still to be treated involuntarily or detained, then it has to be a second opinion from another health professional. A care plan has to be developed in discussion with substitute decision-maker or carer. A tribunal hearing after a week, if it's going to go on. Single-person tribunal, I think after a week is what we're recommending. A decision about appropriate placement treatment. We're not excluding community treatment here. Community treatment orders, if it can be provided safely, effectively in the community, and if the treatment will end and the person recovers their decision-making capability, we think that's reasonable. And then there's a review process. People can appeal for advocacy and support. Critical issue, become more critical since the CRPD, but we've suggested in our proposal that there would be compulsory, that the state would have to make available independent advocacy for people. Community treatment orders, as I've said, that if they fulfill the criteria for decision-making capability, best interests, objective best interests, written preferences, that it's on principle it's hard to argue against, and a lot of patients might prefer it. But it must end when decision-making capability is restored, not these community treatment orders that go on for years. And there is this kind of, it really goes against this, what I'm saying here goes against the traditional medical idea. One of the principles of medicine is if the treatment's working, for God's sake, continue it, don't stop it. It's good, it's working. Community treatment order is working, the person's taking their treatment as prescribed. Well, it would be silly to stop the treatment. I think I might leave the forensic because I think you have a separate act. This comes under criminal justice. I think one of the reasons why the government in England did not like decision-making capacity was because they thought that they would release all of these insane killers on the streets, that they wouldn't be able to control people because community care had failed, clearly. Although the evidence is that homicides by people with mental illness has actually gone down over the last 30 or 40 years. That's interesting. Whereas homicides by non-mental disorder has gone up. But I don't think I'll go into that now, other than to say one can have reasonable forensic provisions within a single future proposal. Then we have the Convention on the Rights of Persons with Disabilities, which are challenging from the point of view of adult treatment. So you can see a number of articles there that, if interpreted in a particular way, might lead one to say, well, one can't ever have non-consensual treatment under the CRPD. I just don't believe that this is feasible. So imagine somebody who's perfectly well goes out on the street, gets hit by a car, develops a cerebral hemorrhage, and they're going to die without an intervention. And they say, go away, nothing's wrong with me. They're confused, they've lost decision-making capability. I cannot believe that their current will and preferences overrides an assessment of their longer-term preferences. So if that applies under these circumstances, one could go through cases where somebody has an adverse drug reaction, becomes confused, or somebody with schizophrenia takes crack cocaine and has a relapse in psychosis, and decide that all the food that's available to them is poisoned, they will not eat or drink, and they're gradually becoming iller as a result. So I think it's very difficult to conceive of no non-consensual treatment. But under what circumstances is it appropriate? Now remember, what we're proposing is the fusion proposal for all people. There's nothing about disability there, unless you're going to argue that a person's impaired decision-making capability, which may only be there for 5 minutes, 10 minutes a day, 2 days a week or a month, is a disability, which to me I think is stretching the notion of disability too widely. So I would argue decision-making capability is not a disability, and therefore somebody who lacks decision-making capability, and where the treatment is the one that they would have chosen, they were able to choose under these circumstances, reflecting in their new language their will and preferences. I don't see that that is incompatible with the CRPD myself. Now, I think we have to reframe our language, that will and preferences has to come into the language, and the idea may be that what one is trying to do is to find the best interpretation of a person's will and preferences, and then to give expression to that work preferences. So in a sense, it collapses decision-making capability and best interest into a single concept. The aim is to discover what is this person's authentic, enduring, deep will and preferences, which requires paying attention to what they're saying now, what they have said, what others might say where things are not clear, and then giving expression to those. And I would argue, if that's the case, that if the involuntary treatment is giving expression to the person's fundamental will and preferences, it's not a substituted decision. It's a decision that the person would have made, that you are actually giving effect to. So I'm saying mental health law is discriminatory. To me, it seems very clear. 50% of my colleagues agree, 50% don't, usually when I do a poll. It's stigmatizing. We're suggesting that a single act would be a solution to the discrimination. And we believe it is compliant with the UN Convention on Rights, Persons with Disabilities that would need to be modified. So the language would need to be re-examined.